Senator Watson, you're recognized.
Thank you, Mr. President. Members, the language of this amendment is copied verbatim from Senator Creighton's Senate Bill 15 as it was filed. Without adopting this amendment, I believe and fear that this bill will violate Senator Creighton's stated intent by declaring void and unenforceable non-discrimination ordinances that have been adopted. Members, this is a lot bigger than what I've heard in some of the questions about just paid sick leave at this point. Workers are discriminated against based on their race, religion, gender, sexual orientation, and a host of other factors every day as part of the terms of their employment. If the Texas Senate wants to protect these workers and ensure that non-discrimination ordinances aren't preempted, then it's not just enough to say it's our intent. Many people on this floor want judges to be strict constructionists, meaning they want the judges to read the words of the law and just the words of the law. Court cases have said time and again that courts must take statutes as they find them, with the words as they find them, and so it's not enough to simply declare one's intent, because ultimately it's the words on the page that will be looked at. Here's the thing. Members, if you mean that you don't intend for this to preempt non-discrimination ordinances, then there is no harm at all in putting that provision in this statute. None. If it is true that that is the intent, then you will gain everything you say the bill was intended to do, including not preempting non-discrimination ordinances. As the bill stands, this would preempt non-discrimination ordinances because they deal with terms of employment and they would be void and unenforceable. Members, I urge you to adopt this amendment and ensure the language in the bill is clear. Mr. President, I move adoption.
Senator Creighton, you're recognized.
Yes, Mr. President, members, I would ask that you keep the bill in its current form as the conversations that I had with Senator Seliger and Senator Perry and many others on this floor. My intentions are certainly clear through the committee process. We had legal opinion after legal opinion, as well as the Attorney General testifying that nothing in this very narrow scope policy that's before you today would require NDO language to be included in the bill. Also within those same opinions that after this legislation's passed, cities are not precluded from continuing to pass their NDO ordinances. And an example of that would be that in 2003 on this floor we passed the Texas Minimum Wage Act. It did not have NDO language in it, and it hasn't ever been litigated. So when we're considering these policies that are in place, sick leave or the other policies for benefits or others that we will talk about in the subsequent bills today, it's very clear that a non-discrimination ordinance language is not needed. And again, members, we keep referencing Senate Bill 15. That's not before us today. So as Senator Watson mentioned Senate Bill 15 and the need for this amendment, it's not relevant because that's not the bill before us. And with that, Mr. President, I'll call a point of order on and request suspension of further consideration of the amendment pursuant to Rule 715 on germaneness.
Bring your point of order up here.